Congress has repeatedly increased the sentences for the possession, distribution, and production of child pornography. Possession of one image depicting child pornography carries a mandatory minimum 5-year prison sentence. Section 2G 2.2 of the United States Sentencing Guidelines outlines the various ways in which that sentence may be enhanced. Often, child pornography investigations involve internet communications with federal agents working undercover. These cases involve complicated computer forensic, search and seizure, and sentencing guideline interpretation issues. These cases require experienced counsel to aggressively litigate these and other issues that often arise. The FBI has increased its focus on federal charges of enticement of minors on the internet. Most cases involve an undercover agent communicating with someone about a child that doesn't actually exist. 18 United States Code Section 2422B carries a mandatory 10-year prison sentence for anyone who uses the mail or any facility or means of interstate or foreign commerce or within the special maritime and territorial jurisdiction of the United States, who knowingly persuades, induces, entices, or coerces any individual who has not attained the age of 18 years to engage in prostitution or any sexual activity for which any person can be charged with a criminal offense or attempts to do so. Now, most of the time the undercover agent is pretending to be someone who has access to a minor, not the actual minor. These are known as, quote, intermediary cases, and different federal courts are split on what type of access the undercover agent can claim to the fictitious child, as well as what type of things can be said to the agent to constitute, quote, enticement. These are complex issues that require an attorney who has experience with these types of cases. Section 2A3.1b6b of the Sentencing Guidelines enhance potential sentences for child enticement charges and other sexual offenses for the, quote, use of a computer. This is a technical term that applies if a computer or interactive computer service was used to, 1, persuade, induce, entice, or coerce a minor to engage in prohibited sexual conduct, or 2, facilitate transportation or travel by a minor or a participant to engage in prohibited sexual conduct. It's important to have an attorney experienced at litigating these types of issues. Subsection B6b is intended to apply only to the use of a computer or an interactive computer service to communicate directly with a minor or with a person who exercises custody, care, or supervisory control of the minor. If you're the target of a child pornography investigation, it's important to involve an experienced, aggressive attorney as early as possible in the process. An attorney can form a buffer between you and law enforcement agents who may very well be trying to get you to talk or provide a statement or documents to them. An attorney experienced with the specific technical and complicated legal issues involved in these types of cases can make a huge difference in the ultimate outcome.